Hello everyone. Today we will be discussing lease agreements and tenant rights violations. We'll look at how courts treat leases, what rights tenants cannot give up, how eviction really works, and how these rules change in commercial settings. Let's start with the foundation, what a lease agreement actually is and why it matters legally. A lease agreement is a legal contract that explains the relationship between a landlord and a tenant. It sets the basic rules of living in a rental property, how much rent is paid, how long the tenant can stay, what the landlord must provide, and what the tenant is responsible for. In the past, courts treated leases mostly as property transactions. Today, U.S. courts see residential leases as consumer contracts, recognizing that landlords usually have more power and information than tenants. This is why tenants receive special legal protections that cannot simply be removed by contract language. Why lease review is important. Many tenants believe that once they sign a lease, they must follow every clause no matter what. That is not true. Courts regularly invalidate lease provisions that conflict with housing laws or public policy. For example, a clause saying, "the landlord is not responsible for repairs," may look official, but it is often legally meaningless. Judges look beyond the paper and ask whether the lease complies with the law. If lease language is unclear or confusing, courts usually interpret it against the landlord, because landlords draft the agreement and control its wording. Now that we understand what a lease is, let's talk about something very important: rights that tenants cannot give up, even if the lease says otherwise. Some tenant rights exist no matter what the lease says. The most important one is the right to habitable housing. This means tenants are legally entitled to basic living conditions, such as working heat, water, electricity, and safe premises. Even if a tenant signs a lease, as is, courts do not allow landlords to rent dangerous or unhealthy housing. In practice, this means that serious code violations are not just regulatory issues, they are breaches of the lease itself. Next, we're going to look at how eviction is supposed to work, and how to recognize when it's being done illegally. In the United States, a tenant cannot be removed from a home just because the landlord wants them out. Eviction is a formal, court-controlled process, and every state requires landlords to follow specific steps. If even one step is skipped, the eviction may be illegal. The process almost always starts with written notice. This notice explains why the tenant must leave and gives them time either to fix the problem or move out. Verbal warnings, text messages, or phone calls are not enough under the law. There are several common types of eviction notices. A pay or quit notice is used when rent is not paid. It tells the tenant exactly how much is owed and gives a short deadline to pay or move. For example, in California this deadline is 3 days, while in Florida it is 3 business days, not counting weekends or holidays. A cure or quit notice is used when a tenant violates the lease, such as keeping an unauthorized pet or causing disturbances. The tenant is given time to correct the problem. If they do, the eviction cannot proceed. If they do not, the landlord may move forward. Sometimes a landlord ends a tenancy without any violation, especially for month-to-month leases. In these cases, the law still requires advance notice, and the notice period is often much longer. For example, in New York, tenants who have lived in an apartment for more than 2 years must receive 90 days notice before a no-cause termination. If the tenant does not comply with the notice, the landlord must then file an eviction case in court. This case is often called an unlawful detainer, or forcible entry and detainer action. The tenant must be formally served with court papers and given a chance to respond and appear at a hearing. Only after a judge hears both sides and issues a judgment for possession can the landlord legally regain the property. Even then, the landlord still cannot remove the tenant personally. The court issues a writ of possession, and only law enforcement, usually a sheriff or marshal, can carry out the eviction. This is why eviction should feel slow and formal. Legal evictions involve paperwork, waiting periods, hearings, and official notices. If a tenant describes an eviction as sudden, frightening, or forceful, that is often a warning sign of an illegal eviction. An unlawful eviction happens when a landlord tries to force a tenant out without going through court. This is illegal in virtually every state, even if the tenant owes rent or broke the lease. Common illegal tactics include changing the locks, shutting off utilities like electricity or water, blocking access to the unit, or throwing the tenant's belongings outside. Some landlords repeatedly enter the unit, make threats, or harass the tenant in order to scare them into leaving. These actions are often called self-help evictions. A related concept is constructive eviction. This occurs when the landlord does not physically remove the tenant, but instead makes the unit unlivable, for example, by refusing to fix serious problems, cutting off heat, or allowing dangerous conditions to continue. In many states, the law treats constructive eviction the same as an illegal lockout. The penalties for unlawful eviction can be severe. In Colorado, a tenant who is locked out illegally may recover actual damages plus either 3 months' rent or $5,000, whichever is higher. In New York, self-help eviction is a criminal offense. In Florida, landlords who change locks can be ordered to pay 3 months' rent as damages. How tenants describe illegal evictions. Red flags. Tenants rarely use legal terms. Instead, they describe what happened in everyday language. Certain phrases should immediately raise concern, such as, "My landlord changed the locks." "They shut off my power." "I never got anything in writing." "They told me I had 24 hours to leave." "No court papers were ever served." When a tenant uses 2 or more of these phrases, it strongly suggests that the eviction may have been unlawful. Legal evictions involve written notices, court documents, and law enforcement, not sudden demands or threats. Let's shift slightly and discuss WA disputes, which often create complex conflicts between owners, tenants, and associations. A homeowners association, WA, is an organization that manages a residential community such as a condominium building, a townhouse complex, or a planned neighborhood. When someone buys a property in an HOA community, they usually become a member automatically. That membership is not optional. It comes with obligations. The owner must follow the HOA's rules and must pay regular dues, assessments, to cover shared expenses. HOAs exist to handle things that individual owners cannot easily manage alone. They maintain common areas, set community standards, like rules about pets, parking, noise, or exterior appearance, and often claim they protect property values by keeping the community consistent. Their authority comes from 2 sources: state law and the community's recorded governing documents, usually called CC&Rs. Covenants, conditions, and restrictions, bylaws, and adopted rules. Even if an owner rents out the unit to a tenant, the WA rules still apply because the documents run with the land, meaning they bind owners and indirectly affect tenants. Because HOAs are powerful, disputes are common. For example, a homeowner may feel the WA is enforcing rules unfairly, issuing fines without proper notice, or refusing to provide records. A tenant may complain that the WA is targeting them even though the tenant is not a member. Another frequent situation is maintenance. An HOA may refuse to fix structural issues in common areas, like roof leaks, pest damage, or plumbing, and owners argue that the WA has a duty to maintain shared elements. State laws differ widely, but many states have baseline rules that HOAs must follow. California uses the Davis-Sterling Act, Florida uses Chapter 720, and Texas uses Property Code Chapters 209 and 202. These laws often require basic due process before discipline, such as notice, an opportunity to be heard, and limits on what fines or liens can be used for. A simple way to remember the system is this: documents create the rules, state law sets the minimum standards, and courts decide whether enforcement was reasonable. Another area where disputes frequently arise is security deposits. Many people misunderstand how strictly these rules are enforced. A security deposit is money that a tenant pays at the beginning of a rental to protect the landlord if something goes wrong. It is meant to cover things like unpaid rent, damage to the apartment beyond normal use, or other losses allowed by law. Even though the landlord holds the money, the deposit still belongs to the tenant. This is one of the most misunderstood areas of landlord-tenant law. Many tenants assume the deposit is automatically lost, and many landlords mistakenly treat it like extra rent. In reality, the law treats a security deposit as temporary, refundable money, not income. While rules differ by state, most states follow similar principles. First, many states limit how much a landlord can collect. Often this is 1 month's rent, sometimes 2. Second, landlords are allowed to use the deposit only for specific reasons, such as unpaid rent or damage caused by the tenant. Normal wear and tear, like faded paint, small nail holes, or worn carpet, cannot be charged to the tenant. Third, when the tenant moves out, the landlord must act quickly. Almost every state sets a strict deadline for returning the deposit. If the landlord keeps any portion, they must usually provide a written, itemized explanation showing what was deducted and why. Now let's talk about subleasing and roommate rights, areas where responsibility and liability often overlap. Subleasing happens when a tenant rents out all or part of their apartment to another person while the original lease with the landlord is still active. The original tenant becomes a sublessor, and the new person becomes a subtenant. In the U.S., tenants do not automatically have the right to sublease or add new occupants. Most leases control this issue directly. Many leases prohibit subleasing entirely, while others require written landlord consent before anyone new can move in. Even if the landlord allows a sublease or a roommate, the original tenant typically remains responsible for the rent, damages, and lease compliance unless the landlord signs an agreement releasing them. This is why subleasing often creates double responsibility. A subtenant may pay rent to the original tenant, but if the subtenant stops paying, the landlord can still demand full rent from the original tenant. State laws can change the analysis dramatically. In New York, tenants in many multi-unit buildings have a statutory right to have a roommate even if the lease tries to ban it. In Texas, subleasing is often treated as prohibited unless the lease specifically allows it. In California, landlords may be limited from unreasonably refusing consent in certain contexts. Repairs and habitability issues are some of the most common complaints in landlord-tenant law, so let's examine how the law approaches them. In residential rentals, the law assumes something very important. Even if a lease never mentions repairs, the landlord still has a legal duty to keep the unit livable. This is called the implied warranty of habitability. It exists automatically in residential leases, it cannot be waived, and it focuses on basic health and safety, not comfort or aesthetics. Habitability is not triggered by every small defect. Courts decide habitability problems case by case. The question is whether a reasonable person would consider the unit unsafe or unsanitary. Conditions like no heat in winter, sewage backups, serious mold linked to moisture problems, rodent infestations, or electrical hazards can become habitability violations because they impact health and safety. Notice is also critical. Many tenant remedies do not arise until the landlord has been properly notified and given a reasonable time to fix the issue. Finally, we'll look at commercial leases and why the legal rules are very different from residential tenancies. A commercial lease is a contract between a property owner and a business tenant for business use. The biggest difference from residential law is that commercial leases are governed heavily by freedom of contract. Courts assume commercial tenants are sophisticated and can negotiate terms, so there are fewer automatic protections. The implied warranty of habitability generally does not apply in commercial leases. Commercial leases often contain traps that don't exist in residential settings. As-is clauses can shift risk to the tenant, meaning the tenant may be responsible for problems they discover after move-in unless the lease says otherwise. Commercial tenants also face complex cost structures like triple net leases where the tenant pays not only base rent but also taxes, insurance, and operating expenses. Finally, COVID made force majeure clauses highly contested. Many tenants tried to argue that shutdowns destroyed the lease purpose, but courts often rejected rent excuses when tenants could still use the space in some way. Commercial tenants must be careful. Financial loss is not the same as legal impossibility, and rent obligations are often carved out from force majeure protection.